When it comes to success as a trial lawyer, there are a number of different things that I think all successful trial lawyers have. And in cases of medical malpractice, products liability, cases that involve some element of science, I think the really successful plaintiffs' lawyers have a commitment to understanding the medicine, understanding the science involved in the cases. And I think that to the extent that lawyers really don't like science, they don't like the medicine, they ought not be doing this kind of work. But within that context, I think it's really agreed by all concerned that there are no secrets to success in the trial practice. Success involves preparation. And preparation starts from the day the case walks into your office. We ought to be thinking about how the case is going to be tried to a jury from the time the client first is introduced to us. We ought to be thinking about our opening statement, about our closing argument, from the time that the client is first introduced to us. Critical to our success is hard work and preparation. There's not a trial lawyer I know that's successful that hasn't had a real commitment and willingness to work hard. And successful trial lawyers work hard, but they also enjoy what they're doing. And we have to be in a situation where we're surrounded by people we like, people that are competent, people that share our passion and our willingness to work really, really hard. Because we know to a high degree of probability that the lawyers on the other side are going to work very, very hard. And we just have to work harder. We have to be better. We have to be willing to spend the amount of time and the amount of money necessary to put on a solid case that's credible. And credibility is what the trial practice is all about. Lawyers who are not credible are not going to win cases. Juries want to believe and follow the recommendations of lawyers they trust, lawyers they believe to be honest, lawyers that they believe to be credible. And how do you get that credibility? Well, you get it by being honest, by being straightforward with juries. You get credibility by being clear and concise in your communications with the jury. And outside the courtroom, you get credibility by being clear and concise in your communications with everybody, with trial judges, with defense lawyers, with clients. And lawyers who are not clear and concise in their communications simply aren't going to be successful, because we all know that juries are much more likely to follow the recommendation of lawyers that have put on cases in a simplified, direct way, and who take complex areas of engineering, complex areas of medicine, and make them simple, make them understandable. And that's just so important to our practice. Finding and retaining quality experts, expert witnesses, is essential in this business. And the experts have to have a lot of the same qualities that the trial lawyers do. They must be clear. They must be concise. They must be credible in their explanations. But it's the lawyers who have to prepare the experts to be that way. That's our job. That's our job. And we've got to be flexible. I think the good trial lawyers are all flexible. We get involved in a case and we have a set of facts. And based on that set of facts, we develop theories about why we should win. But sometimes what happens is the case the facts of the case start to change. And what we thought originally were the facts sometimes are not. And the temptation, because we've got a theory of liability, is to kind of change the facts or try to change the facts to fit our theory. Well, you can't change the facts. You can't change the facts. But we fall in love with our facts. So we try to change them. We try to get witnesses to say things that aren't in reality. What needs to be done in that situation is to recognize you can't change the facts. Well, if you can't change the facts, what do you change? You change your theory. And the danger that so many of us experience is we fall in love with our facts. And so instead of changing the theory to fit the facts, we try to change the facts to fit the theory. And that never, ever works. And I think that another component of success for people to do what we do is to learn from past mistakes. Every trial lawyer has lost cases, and we certainly have lost our share, and there's no shame in losing. But I think the really critical thing about losing cases is to be objective and honest with yourself about why those cases were lost. And we tried to do that, and there's no getting around the fact. Losing cases is ridiculously painful. To have a jury reject your case and reject you just strikes at the very heart of who we are and what we do. But that's okay. That's okay. So long as we learn from our mistakes. And I think long and hard today still about cases that I lost years ago. They just stick with me. And I'm reminded of during the last Super Bowl, Tom Brady was one of the commentators, and he said of all the Super Bowl wins that he had, he spends more time thinking about the cases and the games that he lost rather than the ones that he won. And that's kind of, Tom, you were talking to me, pal. That's me. I mean, I think more about cases that I've lost. And why? Because I've learned more from cases that I've lost. We win cases, it feels good. Why we win, we don't know. Why we lose, we don't know. But we have impressions about why we win or why we lose. And learning from past mistakes is so important. And it's just so critical. And I have a little notebook that I keep. And after every trial, win or lose, I go back and make a page worth of entries about what happened in the case and how things could have been done different. I list the things I think I did well. I list the things I think I could have improved upon. And before every trial, I go back to that notebook because I don't want to make the same mistake twice. And I've made as many mistakes as most trial lawyers can, but I really believe that I've not made the same mistake twice. That's all I can say.